Hello everyone. Today our topic of discussion is formation of UN and human right under the UN Charter. So let's get started. International human rights jurisprudence gained its significance after the Second World War. The incorporation of specific human rights provision in UN Charter paved the way and means for further development in the field of human rights. The UN and its member states are equally obligate to make realization of those cherished provisions of human rights as laid down in the Charter. As a result, the United Nations has adopted the International Bill of Human Rights and many other international multilateral human rights treaties dealing with the various specialized aspects of the human rights of individuals within the framework of the Charter. Since the international human rights law is also a branch of positive international law, the insertion of the such human rights provision in the Charter has not only created the sole foundation of contemporary global human rights regime but also made the individual as a subject of international law and system rather than them a only object of them. The creditor role of the international human rights NGO and their meaningful contribution to the adoption of the UN Charter could also be cited as a unique introduction. Human rights is a contemporary topic of international law and system. With the establishment of the United Nations in 1945, the recognition and realization of human rights and fundamental freedom of individuals have become the most important issue of global organization. That is why human rights issues have also emerged as a for the restoration and the maintenance of international peace and security. The specifics inclusion of the human rights provision in UN Charter also reflect the ultimate reaction of the world community to the horror and terror of the man-made war and conflict. The bitter experience of two devastating world war eventually led to the firm conviction to incorporate the human rights provision in UN Charter. Those initiatives undertaken by the world community marked a new beginning for the promotion and protection of human rights, which was primarily vested in the nation state. Before the United States Charter was adopted, the Human Rights Program of UN have also signified the importance of such right and freedom, individual irrespective of all kind of difference among them. Henceforth, the UN Charter has ultimately recognized the historic man struggle for promotion and protection of basic rights. In this context, the contribution of non-governmental organizations working in the field of human rights could be cited as unique, especially at the time of drafting and incorporating the human rights provision in the Charter. The UN organ and its subsidiary body have also been embedded with the task of realizing the human rights provision as set forth in the Charter. Therefore, the issue of human rights has become the vital part of UN obligation and program sponsored by the UN and its agency in the post 1945 adoption of UN Charter. The Allied nations who fought against the Axis power in the Second World War to destroy the dictatorship and to secure the democracy in the world, resolved to establish a new world organization rather than the revive the League of the Nation. It, it was a London Declaration held on 12 June 1941 that all the nations who fought against Hitler regime made an announcement for working together under a strong international organization. In addition to it, the great power of the world also felt that the need of such global body which would be more effective and powerful than the League of Nations in all its respect, so the world community could restore the maintain international peace and security for all time, and to and the world could also be saved from the horror and terror of war and conflict. The actual term of United Nations was primarily used by the President Roosevelt in the declaration adopted in January 1942. Thereafter, a series of global efforts were made after holding the negotiation and meeting among the nations of at different places of the world, especially for the adoption of the World Constitution, inter alia and international organization. Finally, a proposed framework of such global system was framed in the meeting held in Washington 1945, commonly known as a Dumbarton Walk Preparatory Conference. This was the first concrete global step toward the creation of international organization in the post-Second World War. Subsequently, the said draft proposal was also discussed at the Yalta Conference that is held in the February 1945, in which all the head of powerful countries like USA, UK, Russia took part in the said deliberation. The draft Charter of the United Nations was finally signed on 26 June 1945 at the conference held in San Francisco, USA. The United Nations was also formally established on 24th October 1945 as an international organization. It is worth to mention that the contemporary human rights jurisprudence has gained its significance largely due to the global concern over the gross violation of human rights in the Second World War. Hence, the actual need for promotion and protection of right and freedom of individual has become the most Second World War concern of the international community. Human rights provision in UN Charter. The inclusion of human rights provision in UN Charter also revealed that the promotion and protection of human rights constitute one of the vital objectives to be realized by the UN and its members. Of the term human right and its fundamental freedom are referred to a preamble and seven other provisions of the Charter of the UN, such as the inclusion of human rights provision in the Charter, have the fact created the very basic foundation of the contemporary international human rights jurisprudence. The preamble to be charter in the first paragraph laid down the we the people of United Nations determined to the reframe faith in fundamental human rights, in the dignity and worth of the human person, in the equal right of men and women. Unlike the Convent of the League of Nations, the term "you, the people of United Nations," as a mention in the preamble of the Charter UN, is found to be very meaningful, as it has given the ultimate source of the power, the World Organization. Despite those meaningful words used in the preamble of the Charter, the framer of the Charter also went to the emphasis on the numerous provisions pretending to be the human rights, elimination of colonialism, economic and social cooperation, non-self-governing territory among the others. The basic purpose of United Nations are laid down in the Article 1 of the Charter, which aim at developing friendly relations among the nations based on the respect for the principle of equal right and self-determination of the people, and taking other appropriate measures to strengthen universal peace and security. It further stated that one of the purposes of UN is to achieve international cooperation in promoting and encouraging the respect of human rights and freedom for all the without distinction as to race, sex, language or religion, etc. The Charter recognized that UN obligation for maintenance of international peace and security and obligation to protect the human rights are found to be the interdependent, if it not identical. Therefore, the task of promotion of protection of human rights has become one of the major objectives of the global organization. And interestingly, the entire globe has also been taken as a big family in this regard. The UN General Assembly is empowered under Article 13, Clause 1, Subclause B of the Charter to initiate a study and make recommendations for the purpose of assisting in the realization of human rights and fundamental freedom of all without any distinction among the individual. The General Assembly, as a part of its obligation, has adopted the Universal Declaration of Human Rights 1948, has also many other international human rights documents. Eventually, both the United Nations and its member states do have the global human rights obligation to achieve such mandates, such as provided in Article 55 and 56 of the Charter. Hence, such inviolable mandate laid down in the provision of the Charter indicate the binding nature of the obligation both to the UN and its member state of the Economic and Social Council has the obligation under Article 62, Clause A, Clause 1 and Clause 2 of the Charter to initiate stepped study, recommendation and to respect for observances of the human right and fundamental freedom for all. The Council also have the mandate under Article 68 of the Charter to set the Commission on different fields such as the economic, social and culture of the human right and among others. According to the Council began to establish the Commission on Human Rights in 1946 and the Commission on Prevention of the Discrimination and Protection of Minority in 1947. The another important part of the Charter is a trusteeship system in the UN, in which the main objective for the system is to encourage respect for human rights and fundamental freedom for all. UN Initiative on Human Rights. After having gone through all the relevant provisions of the human rights as set forth in the Charter, it is found that the term human right and fundamental freedom are either defined or nor enumerated in any provision of the Charter. It is also true that the Charter does not contain the relevant provision for implementation and enforcement of the human rights, such as a vacuum found in the Charter eventually create the some debatable issue about the legal obligation of both UN and its member states. However, during the passage of time, the number of international documents of human right on human right, along with the implementation and enforcement mechanism, have been adopted under the even within the framework of work of the Charter. So, therefore, such adoption international instrument on human rights has invariably resolved those debatable issues of binding and non-binding obligation of UN and its member. The other interesting aspect of the UN Charter is that of the domestic jurisprudence clause, as set forth in the Article 2, Clause 7 of the Charter, that creates some rider for the UN and its organs, especially dealing with the human rights issue concerned in the domestic jurisprudence of the state. In the true sense of the term, the United Nations and organ do not consider such domestic jurisdiction clause. Human rights and NGO and UN. The UN history is also found to be closely linked to the activities of the non-government organization NGOs. The international human rights NGOs, consisting of the private individuals from different walks of life and being apolitical and voluntary organization, made a significant contribution to the international standard setting a norm of the human right. They are also consulted by the UN and its agency in making UN policy and program on human rights. Under Article 17.1 of the UN Economic and Social Council mandate that suitable arrangement for consultation of the NGO which are concerned with the matter within the competence. Therefore, the work and contribution made by the human rights NGOs are recognized under the UN Charter. To mention some of those international NGOs such as Amnesty International, Human Rights Watch, International Commission of Jurists, and International Committee of Red Cross, among the others. It is worth mentioning that such international human rights NGOs have not only act as an indispensable partner of the UN for adoption of the global standard and norm of the human rights, but also become the stakeholder for the implementation and enforcement of the human rights law and program. As a matter of the fact, it would have been difficult task for the UN to achieve realize the objective set forth in the Charter without the cooperation and coordination of such human rights NGOs. Even in the Indian domestic legal system, the credential role of the human rights NGOs recognized under the Section 12, Subclause 1 of the Protection of Human Rights Act 1993. This provision insists on the national as well as the state human rights commission to encourage the initiative undertaken by such NGOs and other institutions working in the field of human rights. At last, conclusion. The global initiative and program adopted under the banner of United Nations, especially in the field of human rights, are being carried out as to realize the very purpose and objective of UN. All the principal organs of the UN and their subsidiary bodies have made their meaningful contribution to the development of human rights law and rule for all the people and all the nations. To mention some of those unique contributions made in the area of human rights are such as the protection of human rights, right of the women, children, worker, minority people, migrant and refugee, among the other. Apart from these developments, which are brought under specific international multilateral treaties adopted by the UN, the prohibition of the commission of various inhuman crimes such as genocide, racial discrimination, torture, crime against women and children, crime against humanity and peace have also brought within the fold of positive international law, human right law and system. That's all. Thank you.